State of Wisconsin versus Stephen Avery, starting with Mr. Attorney Kratz. Page 18, number 8. Ready? Let's go. Judge, one housekeeping matter. I don't know if you have reminded the jurors or perhaps, the public as they were brought in, but without an interest in having a Mike Sherman moment. Perhaps all cell phones should be turned off. I don't know if that was something the court has ordered that no cell phones be permitted in the courtroom, and I trust that folks regarding the entrance to the door have enforced that requirement. Kratz, and the attorneys as well, Judge. At least the state has taken care of that, and that's the only other comment we have. Thank you. Court, anything else from the defense? Strong, nothing here, Your Honor. Court, if not, we can have the jury brought in. Jury panel present. The court, good morning, jurors. You can be seated for a brief period of time. The court has already called this morning the State of Wisconsin versus Stephen Avery, case number 05-CF381. In a minute, I'm going to read to you some opening instructions in this case. But before we do that, the clerk will swear you in. So at this time, I will ask you to please rise. Clerk, if you all would raise your right hand. Jury panel sworn. Clerk, please be seated. The court, members of the jury, before the trial begins, there are certain instructions you should have to better understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based on only the evidence presented and the law given to you by the court. Do not let any personal feelings of bias or prejudice about such things as race, religion, national origin, sex, or age affect your deliberations. Do not begin your deliberations and discussions of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. Will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come into contact with any of the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. As the court has previously informed you, the jury will not be sequestered during this trial. That decision is dependent on the jurors not listening to, watching, or reading any news accounts of the case during the trial, nor discussing it with anyone, including members of your family or other jurors. For these reasons, it is vital that you do not listen to any conversation about the case. Do not read any newspaper or internet reports or listen to any news reports or radio or television about this trial. To assure that you are not exposed to improper media coverage, the court is ordering that, for the duration of the trial, you do not watch the local news on television, do not listen to the local news on the radio, and do not read the newspaper unless you have someone remove any articles about this case. In addition, do not visit any internet websites or weblogs which may include any information about the case. Should you be exposed to any reports or communications from any source concerning the case during the trial, you should report that information to the jury bailiff. Do not investigate this case on your own or visit the scene. Do not engage in any experimentation or research relating to any issues, facts, or persons involved in the case. Do not consult dictionaries, computers, websites, or any reference materials for any additional information. The court is aware that many of you have been exposed to publicity concerning this case before you were selected to serve as a juror. Each of you has committed to base your verdict only on the evidence introduced during the trial. It is of vital importance to the parties and to the sanctity of the court process that you remain true to this commitment. Anything you may see or hear outside of the courtroom is not evidence. You are to decide the case solely on the evidence that is offered and received at trial. Evidence is defined as, first, the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received. And third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Attorneys for each side have the right and the duty to object to what